Legal drama and locking of horns by the titans, so to speak. Kapil Sibal really taking everyone by surprise when he today decided to withdraw this particular petition after posing some very tough questions for the Constitution bench.
Congress leader and senior advocate Kapil Sibal, in a complete U-turn, withdrawing his plea challenging Vice President Venkaiah Naidu's rejection of the impeachment motion against Chief Justice of India.
कि हम चाहते थे कि जो भी प्रशासनिक फैसला हुआ है, पहली बात यह है कि किसने किया है, किसने वो फैसला किया है कि ये याचिका 5 जजेस को जाएगी, ये हमें बताया जाए। अगर कोर्ट ने किया होता तो कोर्ट की वेबसाइट पे आ जाता है, क्योंकि कोर्ट का कोई ऐसा निर्णय नहीं था, तो हमने मांग की कि हमें बताया जाए किसने ये ऑर्डर पास किया है।
The Congress's questions over the manner in which the matter was heard in the top court echoed by senior advocate Prashant Bhushan.
Mr. Sibal appearing for the petitioners, for the MPs who had challenged the Vice President's order, he said that, look, we need to know as to how this matter has come to be listed straight away before a constitution bench.
Meanwhile, the BJP reacting to the Congress's U-turn, saying the party's move to politicize the judiciary had failed.
When the petitioners were asked to argue the matter on merits, they lacked the conviction to press the petition and they withdrew it. And there are reasons to do so. All throughout we have been seeing that politics is being brought inside the courtroom.
Mirror now asks, has politics over the CJI impeachment hurt the judiciary? With the plea challenging the VP's decision withdrawn, will this finally draw the curtains on the ugly standoff that has left the judiciary divided? Let's debate.
You're watching the Urban Debate on Mirror. I'm Faye D'Souza. Thank you for joining us. I have a fantastic panel we've put together today. A panel of legal legends who are going to face off on this one question. So while Kapil Sibal withdrew the appeal from the court today, the BJP sees this as a clear victory. For the other side, this is not a victory, this is a point that they have proven. What has this served? Has Kapil Sibal and party managed to draw a question mark and prove a point in the manner in which the Supreme Court is being run? Or have they found themselves at the thin end of the rope, realizing that they can't take this any further? Is it really just politics? And if the petition was going to be withdrawn, what purpose have we served, bringing into question the credibility of our Supreme Court in the eyes of ordinary citizens? That's a question we're asking today. And to help us understand everything that's going on, joining me on the show, Nalin Kohli, spokesperson of the BJP and advocate with the Supreme Court. Pinky Anand, currently the additional Solicitor General of India. We're very happy to have her on the show. Kailash Vasudev, the senior advocate. Arima Sundaram will join us through the course of the show as well. Mr. Prashant Bhushan, senior advocate with the Supreme Court, and Kamini Jaiswal will join us through the course of the conversation as well. I'm going to start with Mr. Prashant Bhushan. Mr. Bhushan, you have today also filed an RTI asking the Supreme Court for the order which instructed the setting up of the 5-judge bench. Can you tell us why you felt the need to file that RTI?
You see, one needs to know as to what was the order, what was the... obviously this has been done by an administrative order, and it seems quite clear that it has been done by the Chief Justice. But we still need to see what is the nature of the order, what was the basis of straight away referring this matter to a constitution bench, because normally this is unheard of, it has never been done before, that a matter is filed, it is not even numbered, and it is straight away referred to a constitution bench. Secondly, if the Chief Justice has done it, clearly that is a violation of the principles of natural justice. It violates the conflict of interest clause, that no person can deal with a matter in which he is directly interested. You see, because this is a challenge to the rejection of the impeachment motion, that is why it was mentioned before Court 2 yesterday, because obviously the Chief Justice can't deal with it. Court 2 said that, all right, let us think about it, you come tomorrow. Now, in between, we find that suddenly the matter is listed before a constitution bench headed by Court number 6. And it's obvious, it seems obvious that the Chief Justice has done it, which is, to my mind, a very, very brazen violation of the principles of natural justice and the conflict of interest clause. In fact, 2 of the charges in the impeachment motion relate to his violating this conflict of interest clause and being a judge in his own cause in that matter involving the medical college case, where he dealt with it first on the judicial side, then he dealt with it on the administrative side. That's one of the charges in the impeachment motion. The other charge is his abusing his powers as master of the roster. Now, this case falls into both categories. He has dealt with a matter in which he is directly interested by using or abusing his administrative power to constitute benches when he could not have dealt with this matter.
All right.
And secondly, abusing it and arbitrarily constituting a bench starting with judge number 6 onwards.
All right,
Why not more senior judges? So therefore, I have asked under RTI, what is the order? Please show me the order and also show me the file notings.
Right. Let me bring in Nalin Kohli now to respond from the BJP. Mr. Kohli, you wanted to respond to this in this face-off. Please go ahead.
उनकी आवाज नहीं आ रही.
Hello.
Mr. Kohli, if you can hear me, please go ahead. Your opening arguments.
But I must say that I found it today amusing to hear some of the principles being put forth by Mr. Prashant Bhushan. I think we need to note it carefully. Mr. Prashant Bhushan invokes, Mr. Prashant Bhushan is invoking the principle of natural justice and then saying conflict of interest against the Honorable Chief Justice of India in constituting a constitution bench of the next 5 senior judges after the 4 senior judges after the Chief Justice. So in effect, first there was a press conference by 4 senior judges, that's judge number 2, 3, 4. Now we must understand this seniority is in terms of who reaches the collegium, who will become the Chief Justice. It's not the seniority in terms of dispensation of justice, because every bench of the Supreme Court is equal when it comes to, when a petition comes before it and it adjudicates on it. So therefore, if by Mr. Bhushan's own logic, the Chief Justice of India has a conflict of interest in this case, then would it not the same principle apply, for example, on 4 judges who came out and spoke on the issue also, which involved the Chief Justice, for them to hear it? So would that not be a case of conflict of interest? And thereafter, if the next 5 senior judges are part of a bench that is questionable according to Mr. Bhushan, so I think the question here should be seen in a broader perspective. This was an unarguable case. What we find happens here is a case, instead of being argued, technicalities, withdrawals, all that starts. I have never seen a petitioner go before the court with a petition that is ready to be heard by the court, and the petitioner then through his lawyers saying, no, please, I don't wish to argue my case. I have a question related to the administrative side. The administrative side of the Supreme Court will be determined by the Supreme Court, not by a lawyer who desires to run the Supreme Court or B, a political party who desires to run the Supreme Court. Is that how the independence of the judiciary will be maintained? So therefore, I think the larger question is that they had no faith in their own petition, because are they saying in that sequence the 5 judges are not capable of hearing it? Why did they withdraw it? And what is the doctrine of necessity? Who will constitute a bench but the Chief Justice? I mean, if you have the doctrine of conflict of interest, then you have to go by the doctrine of necessity also. That it is, but of course, obvious that the Chief Justice will constitute the benches. He is the master of the roster. That is not a creation of the government of the day. That is not a creation of the political parties. That is a creation of the Honorable Supreme Court. It's not mandated in the Constitution. It comes out through judgments, and this is what has evolved through judicial pronouncements by no less than the Supreme Court itself in the nine judges cases involving in terms of setting up the collegium, etc. So what I think is dangerous now is a political party here and a set of lawyers are seeking now to run their political agenda by politicizing the judiciary, by politicizing the Honorable Supreme Court, by constantly attacking the institution of the Chief Justice, by constantly trying to drag judges into this political agenda of theirs, by trying to create doubts and doing great disservice to the dispensation of justice and how the person on the street is going to view this most important institution.
Right.
And will they alone be the so-called conscience keepers when they themselves are changing the rules to suit their own agendas?
All right, let me bring in Mr. Kailash Vasudev. Mr. Vasudev, do you agree that this was basically a display that the appellants had no faith in their own appeal and it was all right for the Chief Justice to constitute the bench against himself?
See, the position is this. It's a sad day. We are dealing with a situation where the institution of the Supreme Court has come into disrepute for reasons which are not in the hands of anybody else but the court itself. You have a conflict of interest between judges, which has always existed, but now it is out in the open. When a conflict of interest comes about between the judges, basically relating to the management and the running of the court, it becomes a matter of concern. To say that the Chief Justice does not have the power to constitute a roster would be wrong. He has the absolute powers. The purposes of constituting a roster is to ensure that there is a freedom, a certain amount of independence in the judges to work it out. Unfortunately, after this the press conference of the 12th of January this year, the schisms in the courts have increased. That schism is leading to trouble and is leading to a very unfortunate situation for everybody. We have an odd situation that in the past 3 years, should I say, the confrontation between the judiciary and the political systems have become very, very open and available. The striking down of the NJAC Act, the National Judicial Appointments Commission Act, with Justice Chelameswar disagreeing. He's the second most senior judge. He disagreed. He says, no, the act should be upheld. The non-filling of vacancies in the High Court, there are 1,100, 600 vacancies lie vacant. The statement is the High Court, the court is not recommending people. The judiciary says that we are recommending people, they're not being appointed. So what I'm trying to get at is, today there is a total divide between the government and the Supreme Court on one side, within the Supreme Court in itself on the other side. How do you balance this? Because you've got to restore the faith of the people in a judicial system which is said to be supreme and is said to be the only bastion for the defense of the rights of the individuals. To my mind, the powers of the Chief Justice to settle the roster are absolute, but he has to do it in a manner which can protect the interest of the system. The division has begun because the powers of the Chief Justice in settling the roster are being questioned by judges themselves. Right. Here is the rub. Here is where we have to find an answer. We are not in a position to give an answer because this is a matter internal to the court. Being internal to the court, it is for the court internally to find a solution. Otherwise, this particular situation of one political party saying that the other is causing trouble and the vice versa and the like is going to lead to flack, which will cause more damage to the institution than we can possibly think will happen.
Right. Opening statements from Mr. Arima Sundaram as well. Mr. Sundaram, the question that arises here is about the bench that was constituted. Mr. Prashant Bhushan in his opening arguments basically said that we don't have an order. He hasn't had the, he hasn't been shown the order, and that's why he's asked for an RTI, through an RTI, asked to be shown the order to constitute that 5-judge bench. The fact that there was no smaller divisional bench that was constituted first before the constitutional bench, do you find that worrying as well?
No, I'm afraid I don't find that worrying. I find worrying what has really happened. For wanting or not the impeachment, it appeared like it was a completely politicized action. And I said, unfortunately, the collateral damage is going to be the judiciary in this. Today, it looks to me like the Congress has taken the judiciary on head on. Today, it was no longer an issue against the Chief Justice, but it's really become an issue against the bench itself, which was hearing the matter, against the court itself. I'm afraid that what is really happening is it's almost like this particular opposition party, I don't know how it's going to help them against their rival political parties, but it seems like they've taken a fight on against the entire judiciary. And that I'm finding very, very difficult. Now, you please take today's matter. You know, it's a very unfortunate and it's a catch-22 situation. Look, what did really happen was that these people have moved a case. Now, they themselves feel it's a huge case. It's, after all, a case of impeachment of the Chief Justice of India. Now, in the normal course, when we in court have a very large case, we like a larger bench to hear it. Privacy went to 9 judges. Aadhaar has gone to 5 judges. Other issues go to larger benches. So it's always in the interest, when it's a matter involving large constitutional issues, that it does go to a larger bench and to a constitutional bench. Now, you may say, procedure followed should have been something else, it should have been this. We've heard both Prashant Bhushan and Nalin Kohli giving their rival arguments on the procedure. But I have always maintained, as the court has always said, procedure is the handmaiden of law. So is really the handmaiden of justice. Now, what is the issue here? An impeachment motion against the Chief Justice of India. Can there be any issue which for the judiciary is bigger than this? In the normal course, should not even a bench of 2 judges have referred it to 5 judges? Should this really not be a matter to be heard by 5 judges? The second question is, all right, then who are the 5 judges? Now, the way it looks to me is, unfortunately, what has happened here is one of these grounds of impeachment is resting, and I said wrongly so, trying to fire off the backs of the 4 senior judges who came out with that statement that there was a problem in administration. But that became one of the grounds of impeachment itself. Now, assume any of those 4 learned judges were on the bench. I mean, they're all such respected people. They themselves would have found it difficult to sit and say, yes, is this a good ground of impeachment or not? That is the ground according to which the judges said that there was a problem in the administration. They are not going to be judges in their own cause. They would never have heard it. So what was left was, all right, if the first 5 judges, for their reasons, may not hear it, because so far as the Chief Justice is concerned, obviously can't hear it.
Yes.
2, 3, 4, 5, that's unfortunately been made a ground for the impeachment itself, which means that
let me please bring in Prashant Bhushan.
Then you go to judges 6 to 10. I don't find injustice in it.
Right.
I don't find injustice in it. That's all I can say.
Let's allow Prashant Bhushan a rebuttal before I bring in Pinky Anand. Prashant Bhushan, this argument that 6 to 10 obviously had to be brought in because 2 to 5 held a press conference against the Chief Justice, and so they could no longer be judges in this particular case.
Not that reason, Faye, not because they held a press conference.
No,
but
that's
it was made one of
not
the
a
grounds
valid
of
argument.
impeachment. That's the point.
Yes, Mr. Bhushan, go ahead, please.
No, that's not a valid argument. The first issue is, who should have constituted this bench involving a challenge to the rejection of the impeachment of the Chief Justice? Could the Chief Justice have constituted this bench of this case? Is there any doctrine of necessity which necessitates only the Chief Justice to constitute benches? In fact, the rules themselves say that if the Chief Justice is unavailable for mentioning, the matter has to be mentioned before court too. In this case, the Chief Justice is disabled from hearing a mentioning involving this case. He is disabled from fixing a bench involving this case, and therefore obviously it has to be done by court number 2. Now, for anybody to say that court number 2 to 5, because they held a press conference regarding the mismanagement of the court by the Chief Justice, therefore disables them from hearing
I said it's
From-
because that was a ground of impeachment.
From hearing or from even deciding which bench should hear this matter, to my mind, is plainly absurd. It is just as absurd as saying that no, the Chief Justice can deal with his own case. He can deal with it either judicial, on the judicial side as a judge, or even fix the bench on the administrative side. To my mind, that proposition is absurd. There is no such doctrine of necessity which compels the Chief Justice to fix the bench. Court number 2 can do it, or if court 2 is disabled, court number 3 can do it. Certainly the Chief Justice does not have to deal with that case himself. And so far as 2 to 5 are concerned, they have no personal interest in this matter. The issue that they had raised was a matter of public interest involving the functioning of the judiciary. So they are not disabled on account of having raised an issue in public interest, which is also peripherally referred to or becomes one of the charges in the impeachment motion, because they have no personal interest in that matter. What personal interest did they have in holding a press conference to point out to the people that the court is being mismanaged?
Right,
It's like saying that if somebody...
Faye, can I just react to that with one statement?
Says that,
May I react with one statement?
If a judge says somewhere, if a judge says somewhere that, look, there is a lot of corruption in this country, then he is disabled from hearing a case, hearing a PIL involving corruption. That's absurd. He has no personal interest in that matter. The question is, you become disabled from hearing a matter if you have a personal interest in that matter.
All right.
These 4 judges have no personal interest in that matter.
Mr. Sundaram,
But
Mr.
the
Kohli,
Chief
I will
Justice
come back
react
to
to
you,
that,
but I
Faye,
just want to
please.
bring in opening arguments by Ms. Pinky Anand, who's also with us. Ms. Anand, thank you for joining us. Your reaction to...
I've been quoted wrongly by Mr. Bhushan.
Okay, I'll come back to you, Mr. Sundaram. Ms. Anand, please, your opening
Can
argument.
I just react to one thing, Faye?
Faye, I don't know. You want Arya to respond to what he was wanting to say?
Okay, with your permission, Ms. Anand, I'll allow Mr. Sundaram to respond. With your permission, Ms. Anand. Mr. Sundaram, go ahead.
Sure.
You feel you
That's
were...
fine.
Yes. I think, look, with great respect to my good friend Prashant Bhushan, I feel he's obfuscating the issue. I am not for a second saying the judges 2 to 5 have any personal interest. Of course they don't. In fact, I also, if you remember right, Faye, I found nothing wrong in their making transparent problems in administration which they believed. In fact, I was very clear on it even at that time. I continue to say so. I find nothing wrong in their doing it, and I feel they should have made it obvious. What I am saying is, since one of the charges for impeachment is what they said and what they meant and what is the effect of it, I feel they themselves would have been hesitant in hearing it and pronouncing a verdict on it. Therefore, it would be but natural that they themselves may not have wanted to hear it on that, because that is one of the grounds which is thought to be justified for impeachment. Are they to then judge what they said and what is the effect of it? That would be embarrassing. I'm not talking about personal interest in Mr. Bhushan. Please don't change my words into what they're not.
All right, that's a fair argument. Let me bring in, let me go over to Ms. Pinky Anand now. Ms. Anand, you want to respond to the arguments that are being made. Will this all be clarified if the copy of that order is made public?
Faye, I don't know where we are reaching. I have never known to go for arguments in cases where the client or the lawyers, the client's lawyer, for example, says on what basis is this bench constituted, whether it is the current 5-judge bench or it is a 2-judge bench or whatever it is. That means we are really talking about everybody having a right to demand and to know and to decide.
We seem to have lost that connection. We'll go back to Ms. Anand. Mr. Kohli, your comments, please.
Sound नहीं ठीक है.
लाइन को क्या हुआ? Yeah. Yes, in fact, I just thought I'd lost my audio because suddenly it went silent while Ms. Anand was speaking. Well, let me, I think, add further to what Mr. Sundaram was saying. And Mr. Sundaram gave a very valid argument in addition to what I was pointing, that in terms of the fact that it is a ground for impeachment. So therefore, I think we today have on the show the doctrine of absurdity. The Chief Justice has a conflict. The four eminent judges who are very senior, judges 2, 3, 4, 5, and they are not the ones who are driving all this political agenda, but they are being used by them and by, a set of lawyers and the political party, the Congress, to somehow do it. They are, according to Mr. Bhushan, they are not conflicted because of them being a ground in the Congress party-driven impeachment. And then judges 6 to 10, that's Justice Sikri, Justice Bobre, Justice Ramanna, Justice Arun Mishra, and Justice Goyal. In their case, they are conflicted in some way. There is no faith in them, who are nowhere connected to this. They are part of the institution. So if that is not the new doctrine of absurdity, then what would be? This is a case of seeking forum shopping. And I think I will say it again, it's absolutely forum shopping. That I would like my case to be heard only before these judges, because I feel, and I think it is incorrect, because the judges themselves are not behaving like that. They are just like judges of the Honorable Supreme Court, eminent in their task on a daily basis. That I would like it to be heard only to them before a person I would desire to be heard in front of. And if I do not succeed in that, then I will run down the whole institution, run down the Chief Justice, raise questions, everything, and then call it that no, this is the only correct stand. Now, I think this is a dangerous situation. Everyone's entitled to have a political agenda. Nobody stops that. But there is a political forum to it. There's a larger issue that also comes out on it. A constitution bench is formed, and Mr. Sundaram, I think, put it very, very eminently, that at the end of the day, you desire a larger bench to hear matters of great import.
Allow Mr. Bhushan to respond to that. Mr. Bhushan, was this a case of bench fixing?
Now being broken up,
Mr.
or
Bhushan,
they are no longer functioning in the normal course. With 60,000 plus pendency of ordinary citizens, of corporations.
Mr.
Every
Kohli.
day there's a discussion that pendency is there, we must finish cases. When they are coming together, the petitioner does not want to hear.
Mr. Bhushan will respond. Mr. Bhushan, respond to Mr. Kohli, please.
Mr. Kohli says that this is a case of forum shopping. Who's shopping for a forum? The only thing that Mr. Sibal was saying was that the Chief Justice cannot fix the bench in a case which directly involves himself. And therefore, that has to be done by court number 2. Or if court number 2 for some reason gets disabled, then by court number 3. It's far from being a case of forum shopping. We were not, or Mr. Sibal was not shopping for any forum. But here what has happened is bench fixing by the Chief Justice by becoming a judge in his own cause. He has dealt with a case directly involving himself. In fact, as I pointed out, that was that constituted broadly 2 of the charges in the impeachment motion. That he had done the same thing, misused both his judicial as well as administrative powers by first dealing judicially with that case of the medical college and then fixing a bench for it. And secondly, his general abuse of his power as master of roster, in which there are few cases which are mentioned which involved, that abuse involved sending the cases directly to court number 10 and 11.
But Mr. Bhushan, my question as a citizen to you, forgive me, I'm not a lawyer, but my question as a citizen to you is this: if we believe that the Chief Justice picked these 5 judges in a case that involved himself, are we suggesting that these 5 judges would have given him a favorable judgment?
That is the problem.
Well, we don't know whether they would have given him a favorable judgment or not given him a favorable judgment. But certainly it was most objectionable. It was most objectionable for the Chief Justice to have constituted this bench, just as it was most objectionable for him to have dealt with that medical college case on the judicial side and thereafter fixed a bench. After all, what had Justice Chalmeshwar done? He had said, let it be listed before 5 senior-most judges of the Supreme Court. And he was perfectly within his right to say that, because in a case involving the Chief Justice, it has to be mentioned to him and he has to fix the bench. But yet the Chief Justice interfered with that, constituted a constitution bench headed by him, decided that case saying that Justice Chalmeshwar's order is incorrect and only he can constitute the bench, and then proceeded to constitute a bench of court number 8, 10 and 15. So therefore, this is most irregular, and I would say displays a brazen disregard of settled norms of conflict of interest and of how the master of roster would be disabled from functioning.
Pinky Anand, current additional Solicitor General of India. Ms. Anand, I apologize to you for the technology failure the last time you were speaking. Please go ahead, ma'am.
You know, Faye, what I am finding distressing is each of these arguments tends to go in one direction, which is how the bench was constituted. I don't know, was that the issue? Is that what anybody goes to court for? You go to court in respect of wanting a judicial order or a verdict on a particular dispute. Today, what had gone before the Constitution bench was a dispute relating to the Vice President's rejection of the impeachment motion. Not a word about that, but what we are talking about at this point of time and what was brought up by the various lawyers who were appearing at that point of time is how the bench was constituted. You know, this is the typical argument which is given when you want transfer of a matter from a particular court or to say that you have no confidence in that court. Don't address the merits of the case. Say that this is not the manner in which a bench was constituted and therefore go for something else. I think we better come back to task. No client, no petitioner has a right to decide which bench will decide his matter, who constitutes that bench. These are decisions taken on the administrative side, and I'm afraid everybody will have to really accept certain practices as belonging to the regime of judicial discipline and to go in that fashion. To argue any kind of concepts and say, no, the bench should have been constituted not like this, but number 1 or 2 or 3 or 4 or 5, whatever the numbers are, should have been constituted like this, is going to lead to a total disarray. This has been happening not for the first time, this has happened earlier. It's a sad testimony to say that, you know, politics has started intervening inside or interceding directly into courts. We should be able to segregate these kind of issues. And imagine that petition itself is withdrawn. What is the purport of that? Is anybody saying, are the lawyers saying that they have no faith in that bench, or only they have an objection as to how it was formed? So the whole debate seems to be only revolving that, and it's actually pathetic. We've come to a stage where we're questioning the institution of justice delivery system and questioning each and every aspect of it. This doesn't augur well for the current situation, and I think we need rectification of that, and we need some kind of rectitude on the part of various players in this entire.
Mr. Bhushan, that question that hasn't been answered yet is what have we achieved with all of this? The bringing about of the impeachment that was then, you know, quashed by our Vice President, the appeal against the Vice President that has then been withdrawn. So the only thing we've achieved really is to bring about a doubt in the minds of ordinary Indians in the credibility of our Supreme Court. Was it worth it?
No, unfortunately, the Vice President has rejected an impeachment motion which was not within his jurisdiction to reject, because it is not for him to decide whether the charges are proved or not. That is the job of the inquiry committee. The Constitution itself says that the Parliament may by law lay down a procedure for the investigation and proof of misbehavior. And the Judges Inquiry Act does that by providing for a 3-judges inquiry committee to be constituted by the Vice President when an impeachment motion is brought. Therefore, all that he has to see at this stage is whether the charges are of misbehavior and whether it has been signed by the requisite number of MPs. Thereafter, the inquiry committee would see whether the charges, they would investigate and hold a trial of the judge and then come to a conclusion whether the charges are proved or not. And then only would the matter go for voting in Parliament. But unfortunately, he rejected that. Now, when that rejection is challenged, then the Chief Justice himself, who is the key player in this and who is a directly interested party, bypasses the settled norms of conflict of interest. No person can be a judge in his own cause, prevents court number 2 from even hearing that mentioning, and suddenly constitutes a hand-picked bench, a constitution bench by himself. Now in this situation, who is to blame? In my view, the blame clearly rests on the shoulders of the Vice President and the Chief Justice, who have, in my view, clearly abused and misused their powers.
Mr. Nalin Kohli, do you want to respond to that? This is an open debate now that everybody's had their chance to speak. If you want
Yes,
to,
I do actually. I do wish to.
I wanted to come in on.
Yes.
I want to come in on a short.
I'll have to go, Faye.
Sorry.
You see, the fact of the matter.
Yes, all right. Miss.
But I wanted to respond to Mr. Bhushan, but if Mr. Vasudev wishes to
Yes,
speak first.
Mr. Vasudev first, please. Mr. Kailash Vasudev,
No,
and
no,
then
go ahead,
Mr.
Nalin.
Kohli.
I'll listen to.
Mr. Kailash Vasudev.
No, please understand. The business of the decision of the Speaker or the Chairman of the Rajya Sabha or the Vice President is to be taken after he peruses and examines the documents before him. You might have a motion by 50 or more MPs, but in the judgment of the Supreme Court in Krishnaswamy's case, it says he has to also apply his mind before he puts it up. The Speaker, or the Chairman of the House normally takes opinions and consultations from other lawyers or constitutional functionaries, which he did. Having taken that view, he had rejected the motion, and that came to the Supreme Court. When it came to the Supreme Court, today the petition was withdrawn. If there was a confidence in the fact that there was more to it than a simple withdrawal, one could understand all this which is happening today, that we're questioning the fixing of the bench, saying that 5 judges don't have faith, we don't have faith in benches 1 to 4. 2 to 5. But the fact of the matter is this. In our system today, would it not be correct to follow the patterns which are outside, that bench fixing is not available to you? In our system, bench fixing is not available to everybody, because if that was to happen, there will be a disaster in our system where everybody would choose a bench. You would like to locate a place where you could do it. Now, I'll tell you how it happens once in a while. There are lawyers who are sons of judges or relatives of judges whose matters don't go before them. When they file the proceedings or the pleadings, they're not listed before a specific judge. That understands that, because that's an elimination process. But to say that you will choose a judge or have a bench to your choice is unheard of. Today, the entire debate has been whether we can have a bench consisting of 2 to 5, or should we have a bench from 6 to 10. That is not a matter of debate. It's a matter which comes within the domain of the judges. Yes, there is one area. Had you no, just 1 second. Had you referred this bench, have you referred this matter to judges 2 to 4 or 2 to 5? We should have seen their reaction also, because they are honorable people. I think they would have recused themselves. Testing that ground is an extreme ground which should have been tested before we make these kind of allegations. To say the Chief Justice is unfair or judges 2 to 5 are unfair is absolutely, unacceptable to me.
Okay, so let me put a layperson question before all of you. And Kamini Jaiswal joins us right now. Ms. Jaiswal, thank you for joining us. And my question is this: there seems to be a general agreement that the 4 judges who were at the press conference would have recused themselves from this particular bench. Is it then difficult to assume or expect that the Chief Justice himself should have also recused himself from this particular constituting the bench? Why is that different?
He has to recuse himself because the recusal by the Chief Justice is expected because the allegations are against the Chief Justice in Parliament. It is that which is being tested. But you should have tested the other 4 judges. They're honorable people. Put it to them, and they would have, by normal concept, recused themselves from these proceedings. There was a recusal issue which arose in the NJAC case. The principles were laid down there. None of these judges would have heard the matter.
Fair enough. Mr. Kohli will respond now. Mr. Kohli?
They are senior judges. They're better.
Mr. Kohli, please go ahead.
I think Mr. Vasudev is making a fair point. But I think the points that I want to bring in is that it's not correct to cast aspersions on everyone because a petitioner, in this case, Mr. Sibal arguing for the Congress party, 2 MPs, and Mr. Bhushan arguing as someone who's concerned with this case, saying that, they only perceive judges 2 to 4 being fair to hear their petition, the Chief Justice or judges 5 to 10 not being so. And that's not a correct approach, because this is exactly what is coming out If not being said directly, it's being said so indirectly. And this is exactly what is also the question. Why is it that someone would not wish to argue their petition? Because someone goes to court that their petition must be heard. And when the petition is to be heard by a constitution bench, someone withdrawing it on a flimsy or a point related to the administrative side. So now we are in a situation where even the administrative side is to be determined by someone who is, may I just finish my point? I'm sure someone can speak after that. I've had the courtesy of not interrupting anyone. I don't know who's interrupting me. Let me finish. So therefore, and the last point that I wish to make is from a common layman's perspective.
Yes.
What is this whole drama, and I'm using the word drama, actually achieving? You have now a situation that constantly petitions are filed, they are withdrawn. In today's case, withdrawn. 5 judges, their regular benches are dispensed with because they have to sit together in a constitution bench. At one end of the scale, people are constantly screaming about pendency. So imagine all the cases that were listed today in front of 5 benches. Those cases couldn't have been heard naturally because the constitution bench was constituted. And thereafter, you build up this whole argument that we are for the benefit of the institution. If you are, you should have argued your petition and not passed a vote of no confidence on the 5 judges. That's Justice Sikri, Justice Bobde, Justice Ramanna, Justice Mishra and Justice Goel, as if they are not capable of dispensing justice.
Kamini Jaiswal will respond. Kamini Jaiswal, go ahead, please.
Yes, may I say something now? I've been waiting for half an hour. 1. The petition was withdrawn because there was a question regarding who passed that administrative order constituting this bench, and it was a very valid question. Because from the very beginning it is being stated that the Chief Justice could not have dealt with this matter either judicially or administratively. What was the great thing that why could that administrative order not have been given to the petitioners? Where was the great secret about who passed that administrative order? All that was stated by the petitioners is, before we go into the merits, we want to know who has passed this administrative order. Talking so much about forum shopping, is this not bench fixing by the Chief Justice? Is it right that a person who is supposed to be a party to the proceedings and against whom the impeachment motion is supposed to be, he can constitute a bench? He can decide who will decide his case. But if somebody else does anything, he is doing forum shopping. What is this? The only question that was raised today was, please give us a copy of the administrative order that has been passed constituting this bench overnight. Because then if we find grounds, we will challenge that order. Because of, and this about pendency, etc., much ado is being made. Who asked them to disband the benches? Normally the procedure is, if a constitution bench is sitting, then there's always an alternate bench, and if the constitution bench breaks for any reason, the matters are taken up by the alternate bench. The Chief Justice in his wisdom decided to disband the benches and made the constitution bench for the full day. A lot of procedures being followed now. Every day the bench sits from 10:30 to 11:25. We are talking of pendency. What are we talking about pendency? It is for the person who is managing the courts to see that the matters get concluded. It is not, I will sit here for 1 hour, then I will sit there for half an hour.
Allow for a rebuttal, Ms. Jaiswal. Allow for a rebuttal, Ms. Jaiswal. Yes, Pinky Anand, if you want to respond. Pinky Anand, please.
Faye, as I said, this sounds like much ado about nothing. The entire discussion is veering away from the merits of the dispute which has been raised, which in any case, I was just hearing Prashant saying that the Vice President had no right to reject the petition. Now, frankly, I find each of these propositions little hard to accept. Is anybody saying that the Vice President has no right to reject a petition? I don't think anybody could possibly, under the Constitution, today say that the Vice President doesn't have a right to reject a petition, A. B, you go with the petition, you withdraw it. That only means that there is no merit in that matter, because that's the only circumstance in which petitions are withdrawn. First of all, whether it would have gone any further is quite another issue, but that would have been left to a judicial decision. Thirdly, whether you get a copy of the order or you don't get a copy of the order, every client is tomorrow going to stand up and say, I'm before this bench, please tell me how this bench was constituted, give me a copy of the order, or else I will not argue my matter, or I will not have my matter argued. I think it is going from, as I said, from bad to worse. We really should realize where we are headed and try to dispense justice. Any merit in this matter would have come out only if the matter itself had been argued. Instead, we are introducing all sorts of insinuations, allegations, pointing out infirmities in the system. For God's sakes, can't we leave systems alone? Can't politics be played outside courts? Does it have to go inside the courts?
Right, Kamini Jaiswal, is this, first of all, my first question to you, is this politics being played inside of the courts, and the withdrawal of the petition, is that defeat?
I don't understand where's the politics. It is a settled position of law in the Veeraswamy matter that all that the speaker has to look at, that the impeachment motion that has been filed before him is in order. He has to see if there are prima facie charges. He has to see if the signatures are of members who are actually members. He does not have to. Nobody can discuss the conduct of a judge either inside or outside Parliament, except after a report of the inquiry committee. That's what the section and the Constitution says. And that was the issue that was being raised.
Kamini, please, please don't reduce constitutional functionaries to something in this fashion.
Mr. Kohli?
Constitutional functionaries will work within the Constitution, whatever is their duty.
Yeah.
Whatever may be
Let
the
them
duty
finish, I will
attributed to
answer.
them in the Constitution, he is, otherwise then he can call, So therefore, it is not a question of reducing a constitutional
But
functionary.
I have a point to make.
What are you reducing others to? Today, what have you reduced the Supreme Court to? What has this government reduced the Supreme Court to?
Right, Nalin Kohli, respond to that. What has this government reduced the Supreme Court to?
This is absolutely, I must say something. Now, I must say something.
Yes,
the government is not involved in anything. The government is not filing the petitions. The government and the party, and which is the BJP, both are saying that anything with the Supreme Court, being an independent institution, must be resolved by them directly. It's the Congress party, a set of advocates who are now their proxies. They are the ones who are going ahead and doing it, and the BJP and the government has to take the blame. That is why in the beginning of the program I use this. This is the new doctrine of absurdity. And look at the absurdity. That you say the speaker is under the settled position of law, not supposed to do so and so, in this case the vice chairman the chairman of the Rajya Sabha, the vice president, and then when the matter comes up before a constitution bench, you say no, I don't wish to argue this. So if it was such an eminently arguable case, one would have argued it.
No, but
so you have an unarguable case, as Mr. Jaitley has written in his article today. And then you say, give me an order. So the new thing to be done is now that Nalin Kohli files a petition and says, excuse me, I don't wish my petition to be heard. I want the administrative order first, saying, how did it end up at this bench? So, I mean, where are we heading? So, I mean, that's exactly the question. And the blame of it is not going to be on the government of the day. The blame has to be on those who file such petitions, withdraw such petitions, and then make a whole spectacle of it.
But Mr. Kailash Vasudev had a point to make as well. Mr. Vasudev, go ahead,
Faye,
please.
I want to, Faye.
Yes, Ms. Anand.
Faye,
Mr. Vasudev, with your permission,
I just want
Ms.
to
Anand,
add a small caveat here.
Yes.
Yeah, you know, ultimately, I just don't understand how anybody in this panel or otherwise can make any statement about the government. I don't know where the government is figuring in this entire scenario. You are having a situation where you have action being taken by various people against the Chief Justice and all the orders that are passed, and we are now talking about the government. I mean, one should stop somewhere at making all sorts of frivolous statements without any basis.
Kailash Vasudev, please. Mr. Vasudev?
No audio. Hello. Yes, I just come. You see, the position is this. On the overall perspective of the entire debate that we've had so far, there has been an angst with regard to the bench which heard the matter. One view is 1 to 5 stand excluded, they had to recuse themselves. So therefore 6 to 10 come into the picture. I mean, are we casting an aspersion on the judges of the Supreme Court in this matter? We are indirectly doing exactly that.
Yes, impeachment.
When we cast an aspersion on judges of the Supreme Court, we are denigrating an institution. If you denigrate the institution, you are not doing anybody a favor. You are causing more difficulties in the future working than anything else. Yes, there is a point which was made by some of the speakers on this panel. They're all honorable people and very good friends at the bar. That today they have to settle down, the judges have to settle down and clear this mess. That mess is something which they have created between themselves. Angst has always been there in the judicial system, starting from Kesav Nanda Bharati's case in '73, starting with the Gopalan movement, starting with the views of Palkiwala, starting with the views of the government staff, that the court should be packed with judges of their own choice. That matter was fully rejected with the basic structure theory. It was further amplified in the 42nd Amendment, the mini constitution. There have been a lot of cases where the independence of the judiciary has been upheld by the judges themselves. Today, we are now playing into a situation where we are compelling the judges to take positions when they can't speak for themselves as to what exactly is happening. Judges 2 to 4 cannot speak. They don't want to speak in this matter because they've said what they had to. Judge number 1 has got the authority to do what he wants. Judges 6 to 10 cannot turn around and say why the petition was heard or rejected. So therefore, please give them the benefit. Let's not cast aspersions on everybody who's there in the system. Give them the benefit of being honorable people because we call a judge honorable. Let them decide their own fate and their own choosings. Let us not cast aspersions as we are doing all over the place. Stop this. Let the system come back to normalcy. We have lost faith. Restore it.
Restore the faith in the judiciary and above all in our Supreme
Faye.
Court, the highest office of...
Faye, can I?
Okay, Mr. Sundaram, all right, a minute to Mr. Sundaram, please.
Yeah. Just a minute, because that's all I want to say. Faye, I think from everything you've been hearing till now, all the accusations that are being made, I thought it all started with a very simple issue of an impeachment motion. Today, it's becoming an onslaught on the judiciary itself. That's why I started by saying I foresaw at that time there was a politicization of this entire impeachment. It was really one party trying to hit another party and using the judiciary as a tool, which was the collateral damage. Today, the attack is on the judiciary. Do you realize that these people who stood up in court, if they had said what they're saying on TV right now, in court, do you mean to say they would have stood up and said, or did they say, we do not have confidence in any of your lordships, will you all please recuse yourself from the case because we have no faith in you? All right, so you don't have faith in 5 judges, you don't have faith in the other constitution bench, you don't have faith in 2 more benches. I mean, what are we doing? Just for your political aggrandizement, are you casting a stone on every single judge of the Supreme Court? That's why I said the Congress party in this particular case seems to have taken it as an onslaught against the judiciary per se. And that's what worries me, because this party in 1975 did exactly that. I'm not a politician at all. I have no political agenda here. But I'm finding that whether it's the BJP or the Congress today, the idea is to minimize the judiciary. And that is something which I'm afraid is happening repeatedly. Because in effect, all your speakers who are supporting what happened today are saying is, we didn't want to argue the case because we have no faith in the judges. Is that what they're saying? That's very sad. That's very sad.
Right, unfortunately, I have run out of time, and I must thank my entire panel for making time for us and helping us understand what is going on. Like Kailash Vasudev said, what the need of the hour right now would be to restore the faith in our Supreme Court. And notice, viewers, we've had this problem now since January, since that press conference took place. Something or the other has constantly come up. One hopes that this is perhaps the end of it. But like has been pointed out by our entire panel, what the average Indian citizen needs is faith in the judiciary. And one hopes the faith can be restored as soon as possible. Thanks for watching.